Hello, everybody. This is Michael Massie, and welcome to another episode of Massie Messages. I haven't been with you in a while, and it's only been because I have been exceptionally busy, but I have been still reading the statutes and keeping up with current legislation. I'm going to talk to you about three areas today. Those are deferred dispositions, jury trials, and marijuana and traffic stops, the relation between the two. Let's talk about deferred dispositions. All of this is criminal justice reform. This is a major piece of criminal justice reform, deferred dispositions, because what it does is allow courts to defer cases. They can hear all the evidence in a case, and a judge can still say he or she wants to defer the case for a particular period of time. After the deferral of the case, the court can use whatever options that may already be available. Say, for example, the court could still find someone guilty. The court could find someone not guilty. The court could reduce the charge to a lesser included offense. And so with deferred dispositions, previously they were only limited to only a few charges in the code. But now the way the code reads, the deferred dispositions are available to the judges. It's a good piece of criminal justice reform because the trial courts are the ones who hear the particular facts in a case, and you don't want to tie their hands. If they think they should defer a case for any number of reasons, they should be able to do that. And so that's a major piece of criminal justice reform. The next piece I want to talk about is as it relates to jury trials. Previously in jury trials, after the jury finds a person guilty, then the jury would automatically, in the Commonwealth of Virginia, would engage in a sentencing proceeding where the Commonwealth will put on some evidence, the defense can put on some evidence, and then the jury deliberates a second time to determine what's the appropriate punishment. The difficulty with jury sentencing oftentimes in criminal cases is that the statute and the punishment may be a very lengthy period of time. And so we all know of our constitutional right to a jury trial, but the way our criminal justice system has been in Virginia up until this point, and this legislation doesn't go into effect until July 1st, oftentimes defendants would not elect to have a jury because the punishment range would be so great that they just didn't think that the risk was appropriate. And just being very candid with you, the advice I would give many of my clients would be, the risk is too great. If you get found by a jury, they have to start at XYZ. It may be 20 years, it may be 15 years. And so one's right is kind of was hampered insofar as having a right to a jury trial because you were always balancing whether the jury would give you what amounts to what defense attorneys would call an excessive punishment, because juries didn't get guidelines to that effect. They just got the punishment range. So now a defendant can elect to have the court sentence him or her after he has a trial by jury. This is one of the most major pieces of criminal justice reform that I have experienced in my days in practice. There are many, many trials that I would like to have before jury, criminal trials, but have not done so because of the punishment range. And so what I expect for lawyers who love to litigate like I do is that you'll see a greater number of jury trials wherein we will elect not to have the jury sentence, but the jury just deliberate on guilt and innocence, and then the courts will still be afforded the opportunity to look at sentencing guidelines. This helps because we want parity in sentencing. We want people treated for similar offenses and similar backgrounds in Norfolk treated the same way as they're treated in Alexandria or Roanoke. And so when that goes to a court and a court has sentencing guidelines, courts are more likely to take into consideration all of the factors under the guidelines and make sure there's parity in sentencing across the state. So that's a major, major piece of criminal justice reform. The last relates to marijuana and stops. And this is another major piece. This comes effective March 1st of this year. So the way this works is that there are a number of things that, as defense attorneys, we would consider pretextual stops. Pretextual stops means that the police officer has a basis to stop you, but he really wants to do something different. He may want to check your car or something like that, or search you. So what this does with marijuana is that it lists the number of what we see traffic violations. Say, for example, there's a list, your license plate doesn't have its light lit. There's some kind of defective equipment. There's no brake light. Your exhaust system is too loud. Your tent is too dark. There's a dangling object from your rearview mirror. So what this statute does is that the officer can't pull you over for those things any further. And that's a big deal because those are the type of things that are used by not all police officers, but some, in an effort to be able to search one's car or search a person. We want to make sure that people's Fourth Amendment rights to unlawful search and seizures are protected, and I think this level of criminal justice reform goes a long way towards that. And one other major piece is that officers can't now say they smell marijuana and use that to search and stop a person. That's a major, major piece of criminal justice reform. There are so many cases that I have wherein the officer indicates that he or she smells marijuana, and sometimes they smell what they think is marijuana. Sometimes it's a black or a cigar. And so that smell sometimes can be confusing. But what happens in the past, before this criminal justice reform, once the officer says he or she smells marijuana, then they have the ability to search everybody, search the whole vehicle. But now that's gone away. So they can say they smell marijuana, but that doesn't give them the liberty to search a person, stop a person, or search a vehicle. So that's another major piece of criminal justice reform. I would like to applaud the legislators in the Commonwealth of Virginia. This level of criminal justice reform will allow and we will see more equity as it relates to people who are charged and punishment that is given to folks. This is not a situation, I don't believe, where legislators have passed legislation that gives anybody a free pass. We all know that we're getting closer and closer to the legalization of marijuana in Virginia. I think what this does and what all of this legislation says to us, the citizens of the Commonwealth, is that our legislators are interested in a criminal justice system that treats everybody on the same level. We're not there yet, but this legislation goes a long way towards getting there. And so I'm very excited about it, and I hope you are as well. If you need to reach me, you can always reach me at my office at 757-397-0003, or you can email me at michaelmassey@massieLawGroup.com, or you can send me a text at 757-285-3435, and I will respond to you as soon as I can. And I will be back with you soon to talk about further criminal justice reform when there is some new legislation. Until then, take care and make sure you hit like and make sure you become a member of my page. Thank you very much.